Hello and welcome. This is our second of our semi-annual seminars, now webinars, from the Cassels Employment Group this year since the pandemic started. Both of these sessions are intended to answer questions that we have received from clients, as well as questions that you were kind enough to submit as part of your RSVP to attend the seminar. So we are focused on employment issues during COVID-19 today. I'm Kristen Taylor. I'm going to start and then pass it over to my colleague, Lori Jessam, and then our colleague, Stephanie DiFrancesco. So I want to pause at the outset simply to acknowledge that there is accreditation for this particular seminar, depending on who you are and where you sit. And I also want to pause a minute on the disclaimer. So some of the questions that we received in response to our request were very specific to individual workplaces, sometimes individual employees. The purpose of today's webinar isn't to answer those questions and provide legal advice for specific circumstances. It is very much to provide general information, obviously from your lawyers, but in connection with some of those hot topics that currently are prevailing, if you will, with respect to COVID-19. If you have specific questions that relate to your workplace, I would invite you to reach out to myself and my colleagues, or with whomever you're comfortable on the Cassels employment team. So my particular session will be dealing with COVID-19 in the workplace and best practices. So I'm focusing primarily on occupational health and safety and accommodation issues specific to those workplaces that either have continued all the way through COVID-19 and the pandemic, or that are have embarked on part of their return to their workplace plan, even if they had a period of time where people weren't coming into work. Lori, when she takes over after me, is going to deal with the specific issues associated with working from home. So we're sort of doing both sides of the coin, if you will. And then just to complete the puzzle, Stephanie DiFrancesco is going to cover some of those cross-border employment issues that have become particularly thorny in light of border closures and such. So to start, health and safety obligations. So the interesting piece here is that there have been no changes whatsoever to the Occupational Health and Safety Act or regulations thereunder. All of the changes actually that relate specifically to COVID primarily are under the Reopening Ontario, a Flexible Response to COVID-19 Act 2020. So the prevailing overarching and obligations remain in the Occupational Health and Safety Act. And as you probably know, there are really three that are overarching and that are in play, if you will, in response to COVID-19. So the first is Section 25(2)(h). That's the obligation for employers to take every precaution reasonable in the circumstances for the protection of a worker. That is cited in every order that I have seen that has been issued by the Ministry of Labour in connection with COVID-19. It may be cited in every order they've ever issued, but certainly in connection with COVID-19. So that's the first one. The second one, Section 25(1), is that the employer shall ensure that equipment, materials, and protective devices as prescribed are provided and then also maintained in good condition. Section 25(2)(a), the third one, is that the employer shall provide information, instructions, and supervision to protect the health or safety of the worker. So that leads us into COVID-19 safety plans. Want to pause just a remark on Reopening Ontario, a Flexible Response to COVID-19 Act. Most of the regulations they're under, and there are many, but most of them relate to Stage 3, and a regulation that came into effect in July and that has been updated 25 times since then. It's where we're finding on a very frequent basis that new and additional obligations are being added. We in the Cassels employment team are trying to stay on top of that and get information out to employers, our clients, as soon as possible. But it is the one that is constantly changing and constantly evolving in the pandemic. So the COVID-19 safety plan, it has become a must-have, a requirement. And there are a number of essential components to it, if you will, that at minimum, employers are required, if not to actually have obligations or have imposed measures, but to have considered. So the first is screening, and that screening obligation has become expanded, and we'll get to it in a little bit because it's now mandatory in every Ontario workplace. Physical distancing and barriers, so that's the 2 meter apart rule, if you will. Plexiglass barriers if possible, if that can't be maintained. Good ventilation. Who knew we all needed to know exactly how our HVAC systems work, but we certainly do now. Frequent cleaning and disinfection of surfaces. Cleaning companies doing very well in COVID-19. Source control masking. PPE, personal protective equipment. And then the important piece to note here is that in situations where one or more controls cannot be consistently maintained, it's especially important that other controls are in place. That we see comes to the forefront wherever physical distancing can't be maintained. It informs some of the decisions that have been released in connection with COVID-19 since the onset of the pandemic. So the first piece, PPE or masks. So, and actually I'm going to pause and take you to one of the cases that deals with masking, if you will, because I think it shows the approach that decision makers as well as the ministry are applying. The first big decision, if you will, that was released came out in July and involves a food manufacturing company from southwestern Ontario. And it was a scenario where the employer had provided face shields, but not masks, and that the workers were required to basically work shoulder to shoulder as part of a production line because of the task they were required to do. So it is one of those examples, if you will, where physical distancing and barriers were not possible, and why then the other controls become so much more important. And the employer had argued after a ministry inspector had mandated that masks be worn, that masks were ineffective and that they required people to constantly touch their masks. Masks would fog up. They had a myriad of excuses as to why they felt that face shields were a better option for them. Which the ministry didn't buy, and the Ontario Labour Relations Board on appeal did not buy either. And they didn't buy it, having reviewed what limited evidence there was already out there in connection with masks, and in particular non-medical masks in the workplace. And they find that the face shields aren't sufficient. And it's important to contextualize this as well, because this decision came out before these masking bylaws and the requirement under the Reopening of Ontario Act came into place. But the board also had some commentary, which I think is important, and I think we all need to be mindful of in this space where we are trying to protect health and safety in our workplaces. So the board said that they recognize we're in a dynamic and evolving situation where facts and risks must be constantly reevaluated in light of new and emerging evidence and experience. Information on how to best control the virus is subject to constant reevaluation and possible change, but reasonable precautions must be taken based on the available evidence at this time. So, and again, this is July 14th. At present, it clearly appears that the risks of not masking at all would outweigh the risks of masking. While there is a risk of contamination from touching face masks while working on the production line, it is subject to mitigation, and the much greater risk would appear to be to have no mask wearing at all. That risk mitigation, they said, was through education. So employees could be trained about not touching their face masks, and that was the better solution in that particular case. So a number of cities came out with bylaws over the summer, and then October 3rd, the regulation was amended under the Reopening Ontario Act. And since October 3rd, masks are required in all workplaces, even those that are not open to the public. So a number of the municipal bylaws, City of Toronto is the one I'm most familiar with, They had passed bylaws that required masking in reception areas or any areas to which the public could have access, but not in private spaces. That did change with this regulation amendment October 3rd. Important to note the exception, and it's an exception that I find deeply troubling, but it is an exception nevertheless. So the exception is for individuals who have a medical condition that inhibits ability to wear a face covering, or they're unable to put on or remove the face covering without help, and then it's, if there's an accommodation requirement. The piece I find troubling is that employers are not entitled to require the individual, the employee, to produce medical documentation in support of that. So we are relying on good faith, and then to the extent that you're not comfortable relying on good faith, or your workplace doesn't permit, or to protect the health and safety of everyone in your workplace doesn't permit somebody in that circumstance to continue to work, then employers have to make the tough call as to whether they're going to prefer, if you will, or feel obligated to allow the greater health and safety, the greater good, to be paramount over that individual accommodation. So those are very difficult decisions, obviously, to make, and do require a full contextual analysis, if you will, before they're made. Also important to note that medical masks, surgical medical procedure face masks, respirators like N95 masks are to be reserved for healthcare workers and first responders only. That also is in the regulation. The COVID-19 screening tool became mandatory towards the end of September. It is now a requirement in every Ontario workplace before a visitor or employee or contractor enters the workplace. So this is supposed to be done on a daily basis. Employers should be keeping records in the event that there is, in particular, any kind of a COVID-19 outbreak at the workplace. It shows that you're doing your due diligence. It will satisfy that defense required in the event of any occupational health and safety issues. So the first question is whether the individual has any new or worsening symptoms or signs, and then there is what ordinary fall, winter would be pretty standard symptoms of a bad cold or a flu, but have taken on a much different perception, if you will, in light of COVID-19. So the employee or contractor or visitor has to answer no to all of those questions regarding those symptoms in order to be admitted to the workplace. Question number 2 is, have you traveled outside of Canada in the past 14 days? On that one, there's a very interesting decision, a labor arbitration involving an employee working for an employer in Sault Ste. Marie, whose children lived in the US, but he lived in Canada. There was a support agreement in place, not a support agreement, a separation agreement in place that provided for him to have visitation rights with his children. And he traveled across the border frequently in order to be a dad pursuant to that agreement. His employer refused to permit him to work because he was not self-isolating for 14 days every time he went to see his kids, not surprisingly. The decision that came out, and this one came out in July as well, the arbitrator found that the employer had to relax its 14-day rule for this particular employee, but had the right to assign him to work and to shifts it deemed necessary to minimize safety risks, to require him to wear additional PPE, take such social distancing and sanitizing protocols it deemed reasonable. So the employer was entitled to heighten the requirements associated with him returning to work without having self-isolated for 14 days, but it couldn't stop him or punish him, if you will, in those circumstances. Interesting to note, of course, that this decision came out before the COVID-19 screening tool was introduced, and that the arbitrator notes that a change in circumstances may very well justify a change in the order. Question 3, have you had close contact with a confirmed or probable case of COVID-19? And again, all questions have to be answered no in order for people to enter the workplace. If there's any yes answered, the individual is to be told to go home, self-isolate, contact their healthcare provider, or Telehealth Ontario. Work refusals have become common, might be an overstatement, but I certainly have many clients who've had to navigate them over the last 8 months. The legislation, as you can see here, as drafted, really is focused on a physical condition in the workplace, right? It's not focused on, and doesn't actually pertain to, what are the classic scenarios where an employee is concerned about their commute to the workplace. They don't want to take transit. They're concerned about transit. I suppose the good news is that there's been very few cases of transmission through transit, or they have anxiety about returning to the workplace more generally. So the work refusal process that's set out in the Occupational Health and Safety Act does not apply to those scenarios. It applies where the worker is at work and determines that something about the workplace is putting them at risk. It's a 2-step process where a worker has staged a work refusal. They remain on site. A health and safety rep from the committee is present during an internal investigation. If the worker's not satisfied with the outcome of that internal investigation, then it goes to the 2nd step, which is getting the ministry involved. And interestingly, the last information that the ministry made publicly available about work refusals was towards the end of June. At that point, it had noted 278 work refusals since the onset of the pandemic. That happens to be 10 times that of any other province. And that all but 1 have been denied. And it appears that they've been denied on the basis that a work refusal wasn't justified unless COVID-19 was circulating in the workplace. So they were looking for the hazard to actually exist, as opposed to an employer not taking measures to better protect health and safety. But you can see what seems to have been the outcome is if you look at that last bullet point there, on September 23rd, the ministry released additional information that showed that since the onset of the pandemic, so this runs all the way into September, there had been 19,411 inspections or investigations regarding COVID-19, and they had issued 16,520 orders. So what you can see is that even if they're not shutting workplaces down or upholding work refusals, they are requiring that additional measures be taken in response to COVID-19. And from the ministry side, they've also announced the hiring of 98 new frontline health and safety inspectors, which is a 24% increase over their current complement. So those inspections are becoming pretty common. If you have a positive case, the steps are as outlined on the slide. I think they're mostly self-evident at this stage. So the employee has to self-isolate, follow direction of public health. Although it is not easy to get somebody from public health on the phone, I can tell you from experience, the effort needs to be made. Any directions provided need to be followed. There may be contact tracing, for example, that you're required to do. You have the obligation to inform workers who may have been exposed. You are not entitled to tell those workers who has COVID-19. That's private personal health information. You are not entitled to out people. And then depending on the extent of the exposure, and it may vary if you're working side by side versus you may have used the same washroom once, those are very different circumstances. Then you can determine who is going to be required to self-isolate. And then I think there should be another bullet point there that I didn't include, probably because it's become self-evident, but that cleaning and hygiene practices are critical. If it was acquired at work, you're required to report to the Ministry of Labour in writing within 4 days. You'd be required to report to WSIB if it applies. And then, of course, you're going to go back to your COVID-19 safety plan and see what, if anything, you can do differently going forward. So we talked about work refusals, the legitimate, that's probably an overstatement, but the bases for work refusals that have now been enshrined, and these are enshrined in the Employment Standards Act, excuse me, are the ones on the screen here. So, you know, if somebody is under investigation for COVID-19, then they are placed on infectious disease emergency leave. If you're concerned about exposure as an employer, that can be a reason to impose infectious disease emergency leave. If they're supporting a family member, and that includes school or daycare closures, there's also an interpretation that suggests that it is that it can apply if somebody chooses not to have their child return to school or daycare. So it's not just the closure itself, but the lack of comfort with what's happening in the schools or daycares, or if there's travel restrictions. These leaves currently run till January 2nd, 2021. I don't know that that's a hard deadline because we've pushed past earlier deadlines in connection with this, the length of infectious disease emergency leave before. The key piece to note about infectious disease emergency leave is that it is like all the other leaves under the Employment Standards Act, so there are reinstatement obligations. To the extent that you have people who would otherwise be temporarily laid off, if at the end of infectious disease emergency leave their position no longer exists because they would otherwise have been laid off, then there will not be an obligation to create a job where a job does not exist. And then, of course, there's also obligation issues in connection with family status and disability pieces. This is a really good segue into Lori's section, which is going to deal with the working from home scenario, because one of the requests that is typically made where an employee doesn't want to return, or does not want to be, excuse me, in the workplace, is that they work from home. Further complicated, of course, by public guidance from both the Ontario government and some of the local governments now that you should only be working if it's in fact essential that you go to work and you can't work from home. So over to Lori.
Thanks, Kristen. Moving on to our next topic, remote working issues on a long-term basis. As much as we all may have come to hate the term the new normal, there's little doubt, I think, that we are in fact in a new world, at least for the time being. In March and April, most employers made rapid adjustments to how and where their employees worked, often with very short-term goals in mind, really just making it through to the next project, the next payroll run, or even just the next week. Now that we've all had some time to adjust and, dare I say, take a breath, many of my clients are taking a look at where they find themselves and their employees now and are asking themselves, is this, and by this I mean a work at home arrangement, something I should be considering in the long term? If you are one of those employers, you may also be asking yourself what kind of changes an employer should make when they move to an entirely or even a primarily virtual environment. And my goal today is to share some information about the types of things you should be considering if you are contemplating a long-term or permanent work-at-home arrangement for your team. I will be covering several areas in my discussion: employment policies, employment agreements, data protection, tax issues, workplace safety issues, and then some general tips on productivity and performance management, as well as potential accommodation issues. So we'll start with the policy discussion. Shifting some or all of your employees to a home office environment on a permanent or long-term basis should prompt you to review your existing policies and consider whether you need some new ones. If you're starting from scratch, hopefully not with any employee policies, but certainly perhaps with a work-at-home policy, and you're preparing one to address your new arrangement, we recommend specifically addressing your expectations regarding the protection of confidential information and company property, availability during business hours and after hours, if that is an expectation you have, responsiveness, connectivity from a technological perspective, what you as an employer consider to be an appropriate workplace within the home or workspace. Think about and develop your practices regarding reimbursement for expenses relating to setting up and maintaining a home office. Give some thought to securing return of company property at the end of the employment relationship. I know that's been a particular challenge for many of my clients. And think too about what your expectations are regarding occasional attendance at the office or meetings with colleagues or contacts or clients. Work at home arrangements have, in the past, often been offered to employees whose roles allow them to work flexible hours or who are not highly integrated into teams or group projects, and that's just no longer the case. Moving employees into remote environments while maintaining a high degree of efficiency, accountability, and team integration requires that the employer take the lead with clear communication regarding expectations, and a policy can be an important underpinning for creating that type of accountable and hopefully functional culture. So I've talked a little bit about what you should think about in your work at home policy, but moving to a work at home arrangement has indirect policy impacts as well. Some existing policies may be indirectly impacted by a work at home, as I said, and we recommend reviewing the following policies and considering what, if anything, needs to be adjusted to address the fact that many of your employees are no longer going to be in the workplace on a regular basis. Workplace safety, and just to give you a heads up, we will discuss some of these topics in more detail later on, but I just wanted to touch on some of the policy issues you may want to consider. Workplace safety policies, you should review your occupational health and safety policy and your basic safety awareness training materials. Make sure that they're updated to address home environments. Accommodation and human rights policies. It should be noted that home offices will be considered the workplace for the purposes of assessing any accommodation obligations that the employer may have. Most accommodation policies do not go into detail about what types of accommodations will specifically be offered to employees with restrictions, and that's advisable and understandable. But if your policy does have that level of detail, it will make sense to review it with an eye to whether anything needs to be revised or expanded to include references to working at home. Attendance and punctuality policies also should be reviewed. Most do reference on-site attendance, and many stipulate that employees must obtain a sick note to excuse absences due to illness. Obviously, it's not necessarily desirable to be sending employees to doctor's offices in the current situation, being the pandemic. So it's advisable to ensure that your policy gives you the discretion to ask for a medical note where you think it's appropriate, but does not make it mandatory in all cases. I also recommend reviewing and updating your attendance policy to refer to log-on times and availability during working hours, in addition to physical attendance at the office. Many employees are using the flexibility afforded to them by work-at-home arrangements to run errands during the day or attend to personal appointments during working hours. If that does not meet your expectations regarding availability in a remote environment, then the policy should make it clear that employees are expected to be logged on and available during working hours, and any personal commitments must be treated in the same way as they were during non-COVID time, i.e. through the use of personal days or vacation time. Another area that requires some attention that's not directly but is certainly indirectly impacted by work at home is overtime. And it's a real area of risk for employers. I think most of us can relate to the feeling that when you're working at home, the workday never really ends. And without the pressures and motivations of traffic, train schedules, and after-school pickups, it's very easy to stay logged on past your usual time. This is not a problem for managerial or professional employees, except for the obvious burnout concerns. But if overtime eligible employees in your organization are putting in that extra time without it being properly tracked and paid, this could give rise to overtime claims that you as an employer did not anticipate or accrue for. I recommend training managers to be mindful of the fact that there is still an end time for everyone's workday, and just because people are at home and likely available does not mean that they are expected to work. Managers should be discouraged from sending employees emails after hours, as that creates an expectation that employees will both read and respond to the message in the evening or on the weekend, which will count as worked time. Leaving aside the policy implications, there could also be changes that need to be made to employment agreements. I definitely recommend reviewing your existing template employment agreements and determining if you may need to make adjustments for the fact that your employees will now be expected to be working at home, some or all of the time, or to address the fact that you may, fingers crossed this doesn't happen, but at some point in the future, once again, be sending everyone home to work in their home environment on very short notice. Some areas that you may want to be looking at and considering are perquisites. Car allowances and paid parking may not be necessary anymore, given how little people will be coming into the office or visiting client sites. Similarly, you may need to revamp or revisit certain allowances like fitness club reimbursements or social memberships. With fitness club fees, you may wish to consider offering to reimburse employees for the purchase of home fitness equipment or online training courses. Other allowances may be suspended or entirely eliminated during COVID, depending on the nature of the spend in question. On a similar note, certain employees holding certain client-facing business development type roles are often given specific annual allowances or expense accounts that they can use at their discretion for entertainment and business development functions. Given the very limited opportunities for such events, you may want to consider eliminating or suspending such allowances during COVID. One area that should definitely be addressed in any template agreement is the idea of home office readiness. Whether or not you expect your employee to maintain a home office is something that should be addressed specifically in the employment agreement. And in particular, you may want to give some thought to what your expectations are regarding connectivity and privacy of the workspace at home. This is true now, I think, even if you're hiring someone for an in-office role, as much as we hope that this is the only time we'll be working at home on an emergency basis during a pandemic. I think we know that there's certainly a possibility that this situation will recur, and you may be in a position to send your employees home to work on very short notice once again. We recommend drafting all employment agreements as if that may happen, and you may have to do this again someday. Some people's template employment agreements may actually have restrictions on working from home, to the effect that the employee's office or role is an in-office position and working at home is permitted on an occasional, pre-approved, as-needed basis. Obviously, you're now going to want the ability to direct employees to work from home when business and workplace safety needs require it, and I do recommend inserting template language in your employment agreement to that effect. Another issue that you may wish to address in your template employment agreements, both in the form of the agreement and the substance of the package that you offer to your employees, is a technology allowance. If your employment agreement does in fact mandate that employees maintain a functional home office, you may wish to consider whether you want to provide technology allowances to ensure that employees have dedicated high-speed Wi-Fi connections or other appropriate equipment, allowing them to work effectively in those home office environments. Moving on to tax issues that arise from moving to a home office environment. Important caveat here, I am not a tax lawyer, I am a lowly employment lawyer. However, I did consult with one of our firm's tax experts, and I am able to share her insights on some of the tax issues that employers will need to consider when moving employees to a permanent or long-term work-at-home arrangement. First is home office setup expenses. In response to the COVID-19 pandemic and the sudden transition to working at home, the Canada Revenue Agency, the CRA, has created a safe harbor for employers and employees of up to $500 in reimbursement for home office expenses. What this means is that employers can reimburse employees for home office costs of up to $500 in 2020 without that payment being treated as a taxable benefit or a taxable income to the employee. It should be noted that this must take the form of a reimbursement. It's not an upfront payment or an allowance. The employees must submit receipts verifying that they have incurred the expense in question before they're eligible for the reimbursement. Generally speaking, employees have a pretty limited ability to deduct expenses related to doing their jobs. As a rule, it's only permitted when the employee works from home more than 50% of the time. If they do meet that criteria, they can be treated, or they can treat certain expenses like heating, electricity, Wi-Fi, as deductible. I'm advised that mortgage costs and property taxes are not eligible. Employers will need to issue what's known as a T2200 to employees who are seeking these types of deductions. This is a form that requires the employer affirm that the employee is in fact required to work from home more than 50% of the time. It is currently unclear whether or not employees will be eligible for T2200s and the resulting deductions if they have the option to work from the office, even if they have chosen to work from home for the preferred safety arrangement. I'm advised that we are waiting for guidance from the CRA on that front, and hopefully we'll be able to provide an update soon. Another issue for employers to consider when they're thinking about the tax issues that arise from work at home arrangement is what happens when an employee relocates out of the province while they were working at home. And as someone who started their life in the Maritime provinces, I know that a lot of my peers are retreating to Nova Scotia, New Brunswick, Prince Edward Island during the pandemic, where they're able to work while they're near friends and family and in the Atlantic bubble, avoiding the bigger cities. So what happens when one of your employees does that? Employers usually remit income taxes based on the province in which the employee actually performs their work. But if your employee relocates to another province during the work at home period and no longer reports to a physical workplace, you as an employer can remit for that employee on the basis of the province in which your payroll is actually located. So that may be something to think about as well. There is a very particular issue that arises, or a very particular risk that arises for companies that are located in the US and that hire Canadian citizens to cross the border to perform their work in the US. The fact that the individual is now working at home, providing their services to the US-based company at home in Canada, could give rise to Canadian tax obligations for that US entity. It could be required to file a Canadian tax return, or depending on the nature of the employee's activities and role within the organization, it could even be deemed to have created a permanent establishment in Canada, which could result in obligations to remit Canadian corporate taxes. So if you, as an employer, are in the position of having employees crossing the border to do their work, please do consult with your tax experts to make sure that you plan appropriately and mitigate your risk on that front. Another area for employers to consider when they're dealing with the transfer to work at home is data security. So employees who are working at home are now accessing your confidential and proprietary information in a relatively uncontrolled environment. This can be a challenge for employers in terms of ensuring that your information and systems are used responsibly and in accordance with your policies. We recommend providing updated training and policies addressing certain issues that are specific from a data protection perspective to a work at home environment. One would be the use of company devices by others in the home. I think we know that a lot of families are under pressure to provide online learning for their children. You should have clear communication with your employees about whether or not they're permitted to use their work laptop for such purposes, and if so, under what circumstances. You should address specifically, it's a similar note, password protection for company-owned devices, and making sure that they maintain a good practice of locking them while they're not in use. You should also think and educate your employees about printing, retention, and destruction of confidential information. Some companies have gone as far to actually create security protocols that prevent remote workers from printing anything at home, and you may wish to do the same. You should also communicate clearly with your employees about your expectations for a secure environment for phone calls and virtual meetings. This will be of particular importance for companies whose remote workers deal with market sensitive or confidential client information. And then finally, you should also provide your workers and employees with tips for creating a secure home Wi-Fi network so their neighbors can't hop on and spy on what they're doing. I touched on this briefly earlier when I talked a bit about the policies that you'll need to review and consider as part of a work at home transition. But workplace safety is something that does need to be top of mind as part of the transition to work at home. It may surprise people and employers to learn that the definition of workplace in most occupational health and safety laws is broad enough to include a home office. This creates a particular challenge for employers in terms of balancing their obligations to ensure that employees are working in a safe environment versus the desire to protect employee privacy in their homes. You don't want to ask too many questions about the environment in which the person is working. However, given that employers are obligated to assess the safety of their workers' home offices, we do recommend the following steps. Number one, ensure that your policies actually contemplate and address home offices. spoke about this earlier as well, update basic health and awareness, basic health and safety awareness training to address home office issues. Provide employees with specific guidance on how to make their home offices safe for work, and ask them to specifically verify that their home office meets your criteria. You should also be prepared to provide assistance if the employee or the worker identifies any particular safety issues in their home. And I'll start with domestic violence. There's a lot to unpack here, obviously, and it's important to remember that most provinces specifically charge employers with addressing workplace safety issues posed by domestic violence. And if you have an employee who says that he or she cannot work safely from their home due to concerns with domestic violence, you do need to offer support by way of a potential leave of absence, some of which are mandated by our provincial employment standards legislation, and referrals to employee assistance programs or local resources regarding domestic violence. I also recommend in these circumstances specifically discussing with the employee emergency protocols that you'll be following if the employee reports that they feel threatened, or if they're experiencing violence at home, or worse, if they are no-show, no calls for their scheduled log-on times or shifts. If it's possible, you may wish to consider offering a return to the physical workplace to give them the opportunity to work outside of the home. A less fraught issue is the lack of ergonomic work furniture. Although employers in most provinces are not statutorily obligated to provide all tools to be used at work, if you have moved your employees to a work-at-home environment from an office environment, you would be obligated potentially under human rights legislation if it's related to a disability, but certainly even potentially under the contract of employment itself to effectively address any safety issues caused by the fact that your workers do not have ergonomically appropriate workspaces. We recommend considering allowing employees to sign out office equipment from the physical workplace and use it at home for the duration of the work at home period. And you may wish to also consider investing in virtual ergonomic assessments and offering allowances for the purchase of appropriate office furniture. Another issue to consider is isolated workers. If you know that an employee is working in isolation, it makes sense to schedule regular check-ins and to ensure that your contact information for their emergency contacts is up to date. And also be mindful of any signs that they are struggling with the isolation caused by the pandemic, because mental health is, of course, part of, effectively addressing mental health issues is part of the employer's obligation, both under workplace safety and definitely under human rights legislation. So managing employee performance remotely can be a challenge. I think we all know now that many employees are struggling with a brand new environment in their home, between trying to effectively provide homeschooling or elder or childcare. It can be difficult to provide the same level of attention to their duties as they may have given you when they were in the office environment. I do recommend tracking hours of work and monitoring potential overtime. We've talked a bit about that before. It's a risk management issue for employers. However, the balance you're trying to strike here is effective monitoring versus micromanagement. It's important to remember that workplace harassment complaints can come even in a remote environment, and managers should be educated about how to strike a balance between being connected, making employees accountable, without bombarding them with emails or constant Zoom calls or WebEx calls, and constantly monitoring progress in a way that may be seen as micromanagement. If an employee is struggling, consider offering coaching, perhaps on time management or just performance management, or technological support. The transition to work at home does require a certain technical facility that many employees may just not have, and they may need some assistance with adapting. But it is important to adhere to your usual protocols regarding discipline and performance management, with, of course, appropriate adjustments for the work environment, the remote environment. But you do want to maintain that consistency of practice because you've developed those protocols for a reason. Finally, I wanted to speak a bit about accommodation. So it's come up a few times in the presentation so far, but it's important to reiterate that employers are obligated under human rights legislation in every province in Canada to provide accommodation for restrictions that are related to protected grounds. I've highlighted two that I think come up most frequently in the work at home environment: family status, which is defined as the status of being in a parent-child relationship, and then disability. So if you have an employee who's struggling with performance, with connectivity, with responsiveness, with providing you with the full attention to their duties that you know you're entitled to under the employment agreement, you should consider making modifications that address their concerns. A couple of things: you're not obligated to allow people to work half the time for all of the pay, or in a way that's not delivering on the key responsibilities of their role. You don't have to accept poor performance or poor attendance and call that accommodation. What you do have to do is make adjustments that are responsive to the restrictions, that still allow you as an employer to get some value from the employment relationship, but provide the employee with the support and the adjustments they need to be able to stay in the employment relationship while still caring for whatever their family obligations are or dealing with their restrictions due to disability. So some specific measures you may want to consider is modified work hours or duties. Some parents may be splitting online education responsibilities, and one parent may not be able to work in the morning, but they would be available in the afternoon. If you can shift hours, consider that. Some people may need to come into the office because their home environment, for reasons that are related to child or elder care, simply aren't suitable to providing them with a safe and quiet place to work efficiently. So if you can consider that, if it's an option, please do. Disabilities such as visual or audio impairments may make it difficult for employees to work from home without the right assistive equipment. And if you had been providing that in the workplace, or they have a newly developed disability where they require that accommodation at home, you should consider that, and that would be your obligation as an employer. And then finally, in a worst case scenario where the employee is completely unable to work because of these obligations, you can consider a leave of absence. And then ultimately, depending on how long those restrictions persist, you may end up in a situation where you need to frustrate the employment agreement, but certainly given the timeline that we faced in the pandemic thus far, you would not likely be there now. And still your focus should be on how you can accommodate people who have restrictions due to any protected ground. But of course, I've highlighted family status and disability because those are the ones that we've seen come up most frequently in the pandemic. So that was a bit of a whirlwind through the various policy considerations and practical measures that employers should turn their mind to when they are considering a transition to a work at home on a long-term basis, or potentially permanent. I hope it was helpful. I know we covered a lot of ground, and I am going to now turn you over to the capable hands of my associate, Stephanie, who will take you through some particular immigration issues that you need to consider that are related to COVID.
Thank you, Lori. The COVID-19 pandemic has significantly impacted cross-border business travel. So in my presentation today, I will provide you with information about the current requirements applicable to foreign nationals who need to enter Canada for business purposes. Presently, there are 4 buckets of requirements, and I'll provide you with an overview of all 4. Normally, there's only 1 bucket of requirements. It's unclear how long these additional requirements will be in place, though we expect that they'll be in place at least until the end of the year and likely well into next year in some form. As with everything else this year, the requirements and restrictions applicable to cross-border business travel are continually changing and being updated. So before sending a worker to Canada for a business reason, ensure that you speak with legal counsel to make sure you're aware of the then current travel requirements. So the first requirement is just meet the regular entry requirements. With any proposed entry into Canada, whether it's during the pandemic or otherwise, There are 4 eligibility questions to be answered to determine what the foreign worker needs to enter the country. Question 1 is, does the worker need a travel visa or a visitor visa? Citizens of certain countries are visa exempt. Some examples are American citizens, Mexican citizens of any European nation, persons with a Hong Kong passport, and many others. And then other persons are from visa required countries. Some examples are citizens of China, citizens of India, and citizens of most African and South American nations. For the purposes of this presentation, what you need to know is that if the worker you want to send to Canada requires one of these visitor travel visas, they have to apply for that visa in advance. They can't apply for one at the port of entry. The Canadian visa offices abroad in most jurisdictions are either closed or operating at reduced capacity, so there will likely be processing delays obtaining these permits. The second question is a electronic travel authorization required? And the answer is generally yes, if the person is a citizen of a visa exempt country other than the United States. An ETA is very quick and easy and inexpensive to secure and not in any way impacted by the COVID-19 pandemic. The third question is, does the foreign worker need a work permit? If the answer is no, that person can likely come as a business visitor with appropriate supporting documentation. And if the answer is yes, and they don't already have a work permit, the next step would then be to determine what work permit options are available to them and what's the quickest and easiest way to secure one. And then finally, the fourth requirement is that the foreign national must not be criminally inadmissible. Someone is generally criminally inadmissible to Canada if they have committed an offense outside of Canada that would be considered a crime in Canada. We do see from time to time, for example, American citizens who otherwise meet the entry requirements. They may have a DUI, which is a sort of relatively common minor offense in the US that is considered to be a more serious offense in Canada. So something like that may impede the traveler's ability to come to Canada for a business purpose, especially if that charge is recent or there are multiple. So before sending a foreign worker to Canada, ensure they either have a clean criminal record or you're aware of what their criminal record is so that you can work with Immigration Counsel to figure out what additional paperwork will be needed for that traveler. So requirement 1, meet the regular entry requirements. Requirement 2 is navigate the border closure. The Canadian border is currently closed to persons who are coming to Canada for optional and discretionary purposes. So no matter whether your worker will be entering from the United States or any other country in the world, they must establish that the purpose of their trip is not optional and discretionary. So generally they must be coming for a work purpose. They must also generally establish that they physically need to be present in Canada at this time, that the work that they're doing can't be done at some other time or can't be accomplished remotely. And if you are seeking to bring a worker into Canada from somewhere other than the United States, there may be additional requirements. For example, having to already have a work permit or work permit approval, be coming for a national interest purpose, or be coming to provide medical, emergency, or other essential services. Requirement 3 is have no COVID-19 symptoms. Having no COVID-19 symptoms is both a requirement to board most commercial airlines. It's also a requirement to enter the country. It's also just good practice not to send a foreign worker on a business trip if they're not feeling well. Before traveling, the worker will have to undertake a health check performed by immigration officers that just consists of answering questions about their health and general observation. 48 hours prior to when they plan to enter the country, they will also have to use the ArriveCan app, website, or toll-free number and answer questions on that site as well. And requirement 4 is either have a quarantine plan or establish that you're exempt from the quarantine requirements. And I'll first talk a little bit about the quarantine plan. So unless an exemption applies, any foreign national or Canadian citizen re-entering the country from abroad is required to quarantine for 14 days. That 14-day quarantine requirement begins, it's the 14 days following their entry into Canada. No period of quarantining before they enter the country cuts down that 14 days, nor does taking a COVID-19 test abroad. To gain entry to the country, immigration officials must be satisfied that the traveler has a satisfactory quarantine plan. The plan needs to include features like the identified location where they will be quarantining, which can be a hotel or Airbnb. It must include the transportation, so how they will safely get to that quarantine location. They must be able to account for how they're going to provide for sort of essentials and necessities during that quarantine period without going out to get them themselves. So their plan should include things like indicating that they've brought a 14-day supply with them of sort of essential personal items that they will need, and that they are aware of, ordering services that they can use to have groceries delivered or to have food delivered to them while they're in quarantine. And if you are, if a foreign worker is planning to stay with friends or family in Canada while they're on a business trip, you'll also want to ensure that their quarantine location does not include vulnerable persons. And generally those are persons who are immunocompromised or who are older than 65 years. Using the ArriveCan technologies, the government is also monitoring travelers to ensure that they are following the quarantine requirements. So in addition to entering health information, the traveler is also required to enter information about their quarantine location. Generally, a traveler will be checked in on at least once during the 14-day period. It's not uncommon for 2 or 3 check-ins. And there are consequences if a traveler is found not to be in compliance. So 14-day quarantine period is rather onerous and may make certain business trips impractical. If you're planning to send someone for a 1 or 2 day work event, it may not be practical to send them if they're going to have to be in quarantine for 14 days first. So the new pilot project that's been introduced in Alberta may be some welcome news to employers. The pilot project is aimed at reducing the quarantine time for persons who are not exempt. And so the aim is to reduce it from 14 days to 2 or 3 days. The pilot project is being operated at the Calgary International Airport and the Coutts Land border. And the eligibility requirements are: you must be an international traveler coming in on an international flight if you're using the program at the Calgary International Airport. You have to volunteer to take 2 COVID-19 tests, which are free at the port of entry. You have to be staying in Alberta for 14 days before going on to any other place in Canada, or you can be coming to Alberta for less than 14 days if your trip will be in Alberta for the entirety of the trip. You have to have a satisfactory quarantine plan for the 2 or 3 days that you're in quarantine waiting for your test results. You must be symptom-free, and you must also have had no contact with any confirmed cases of COVID-19 in the 14 days prior to your travel. So if you're doing business in Alberta, this pilot project may be a good option for your workers if they're willing to volunteer to participate in it. So the question every employer wants to know, what are the quarantine exemptions? Can I get my worker into Canada without them being required to quarantine? The first item that it's important to note is that the quarantine exemptions cannot be applied for in advance. A worker must request to be exempted at the port of entry. And so what are the quarantine exemptions. There are several of them. They're very limited in scope, and they're interpreted quite narrowly as well by immigration officers at the port of entry. Ultimately, whether or not a worker qualifies is at the discretion of the reviewing officer. So before sending a worker to Canada seeking the exemption, you'll want to ensure that you connect with Immigration Counsel to ensure that you have all of the documentation that you need and that you are persuasively conveying why the worker qualifies for the exemption. You'll also want to have a backup plan if the officer ultimately decides that they are not exempt. Is that worker going to turn around and come home? Or are they also going to have a quarantine plan ready and stay for the 14 days and then attend to their work location? So on the slide, I have listed 2 quarantine exemptions that are likely the ones that are sort of most likely to be applicable to an employer who does not provide health services or transportation of goods type services. So the first exemption is for persons who the Chief Public Health Officer has determined provide an essential service. What is important to note is that many provinces have designated certain industries or types of work as an essential service for the purposes of their provincial or territorial reopening plans. That's not the same criteria applied for immigration purposes. So there is a specific list of persons who are able to enter provided essential service. And the one on the slide sort of gives you an example of the specificity of the types of people who can be exempt. So for example, technicians and specialists who are entering Canada to maintain, repair, install, or inspect equipment to support critical to provide their services within 14 days of entry, and they can provide a reasonable rationale for the immediacy of the work and the inability to quarantine. So if, for example, there's been there's an issue with equipment, a piece of equipment has broken, you need to get an emergency repair person in to fix that equipment promptly. There's likely a way to get that person in without them having to be quarantined for 14 days. If you're simply seeking to have someone enter the country to attend a meeting or do some work in a business that would be considered an essential service, that is very unlikely to fit within a quarantine exemption. The other exemption on the slide is for persons who need to enter the country to get from their sort of place of residence to their place of work. So for example, this exemption is really for folks who live on one side of the border and work on the other side of the border. So think, for example, of a Canadian nurse who lives in Windsor but works at a hospital in Detroit, or vice versa. These are individuals who have to cross the border every day to get to their regular job. The exemption is likely to apply to them. The exemption is not likely to apply to someone who, for example, is regularly employed by an American employer. They live in the US, not anywhere close to the Canadian border, and in normal times they would have flown to Canada regularly to attend client sites or to attend various offices of an affiliate business. Those persons are not attending their regular place of work in Canada and are unlikely to be exempt from the quarantine requirements. There are, as I said, sort of a number of other exemptions, and discussing those is beyond the scope of the presentation today. But if you are looking to send a foreign worker to Canada and would like to consider whether a quarantine exemption applies, I'm certainly happy to consider that with you on a case-specific basis. And then before I go, there are 2 additional items I thought it was worth touching on. First is domestic travel. So if you're thinking of sending a foreign worker to another province for a business trip, it's worth noting that they will still be subject to health checks if they're traveling by air. but also ensure that you are aware of any provincial territorial restrictions on travel. So for example, there is the maritime bubble right now. There is free travel within the maritime provinces, but restrictions on those outside that region seeking entry. Same thing with the territories. The territories have sort of created a little bit of their own bubble with restrictions for persons who are not in the territories entering. So again, make sure that you're aware of any provincial or territorial restrictions. And then departing Canada. So before you send a Canadian worker or worker in Canada outside of Canada on a business trip, I would say first be reminded that the Canadian government's recommendation is still to avoid all non-essential travel outside of the country. So I would suggest first seriously consider whether it is necessary to send that worker outside of the country at this time. If it is truly necessary, ensure that you know the travel and border restrictions of the travel destination. Depending on the place they are traveling to, those restrictions can vary considerably, and they are regularly changing. And one, I guess, parting thought before I conclude my presentation is that it's now more important than ever to seek legal counsel before sending a foreign worker to Canada, given the number of changes and current restrictions. So here at Cassels, I'm certainly happy to help you navigate the current COVID-19 restrictions. And on behalf of Kristen Taylor and Lori Jessam, I'd like to thank you all for joining us today. If you have any questions, feel free to let us know, and we will consider incorporating those questions into future webinars. Thank you.